In our lecture series relating to landmark judgments on cybercrime, now we will discuss about the third important judgment, and that is Pune Citibank Mphasis call center fraud case. And regarding that, in the introduction we will discuss about the digital security, then data governance, and the privacy regulation. So, in that regard, we will discuss the very fact of this case relating to fraudulent transfer of funds, then use of sweet services of a nationalized bank, then the fake email accounts created by the accused through forged documents. So the very issue revolving around that case is relating to sections 43A and section 66 of the Information Technology Act 2000 and sections 420, 465, 467 and 471 of the Indian Penal Code of 1860. And finally, we will discuss about the very judgment, and in relation to that also the limitations of Information Technology Act 2000 and the enactment which led for the introduction of the Bill of Digital Personal Data Protection Act, which was consequently enacted in the year 2023. Then we'll conclude our discussion on this third most important case relating to cybercrime. So, the very Pune City Bank Mphasis call center fraud case of 2005 acts as a significant milestone in the field of digital security in India. Its employees exploited its loopholes and planned a detailed scheme to conduct this fraud. Its legal implications address the need to a new bill to combat cyber crimes and safeguard individuals' personal data. So, the very introduction of this initiation of this case led to the introduction of digital personal data protection bill, which emerges at that time as a step towards enhancing data governance and privacy regulations, aiming to fortify India's cyber security posture and develop trust in the digital system. So, the case of Pune City Bank Mphasis call center served as an alarm which raised the very concern regarding personal data protection and prompted a critical examination of legal mechanisms involved. At the very head of the matter lays the Information Technology Act 2000 legislation aimed at regulating electronic transactions and providing a legal framework for digital governance. However, as the case unfolded, it became evident that the very scope and provisions of the Information Technology Act 2000 were inadequate in addressing the evolving landscape of cyber threats and ensuring robust protection for sensitive information. So, the most notable incident that underscored the fragility of our digital infrastructure, and that is relating to this case, which occurred in 2005 at the Pune Citibank Mphasis call center, where a group of employees orchestrated a meticulously planned fraud scheme, siphonning off millions of dollars from unsuspecting customers' accounts. This brazen act of financial malfeasance not only exposed glaring loopholes in banking security protocols but also raised profound questions about the efficacy of existing legal frameworks in the combating cybercrimes. So, against the very backdrop of rapid technological innovation and the growing prevalence of digital transaction, the Pune City Bank fraud case served as a wake-up call, prompting a critical examination of the legal mechanisms in place to safeguard individuals' personal data and to combat electronic crimes. At the very heart of the matter lay the Information Technology Act of 2000, a pioneering piece of legislation aimed at regulating electronic transactions and providing a legal framework for digital governance. However, as the case unfolded, it became evident that the scope and provisions of the Information Technology Act of 2000 were inadequate in addressing the evolving landscape of cyber threats and ensuring robust protection for sensitive information. So, in response to these shortcomings, policymakers and legal experts embarked on a journey to bolster India's cybersecurity posture and enhance data privacy regulations. This culmination of these efforts came in the form of the Digital Personal Data Protection Bill during that period, a landmark piece of legislation designed to usher in a new era of data governance and privacy protection. So, in that connection, we will now examine the very facts relating to this important judgment on cyber crime. So, in the year 2005, workers at the Pune City Bank Mphasis call center committed a fraud by transferring funds from the bank accounts of some innocent customers into their personal accounts. The employees used to be checked when going in and out if they carried any numbers with them to prevent them from copying any numbers. After quitting their jobs, they carried out the bank details of 4 dormant accounts with them and transferred funds into their Indian accounts using the SWIFT services, which is otherwise known as Society for Worldwide Interbank Financial Telecommunication System, is carried out by every bank. These were the accounts which had not reported any activity for some time. So they made fake email accounts and bank accounts in Pune to transfer funds. Neither the original account owners got any notification of bank transfer, which is usually given in case of bank transfer, nor the Citibank or Mphasis detected anything unusual. This was due to the strategy employed by the accused, which included modifying contact information of the concerned account and manipulating transaction records. So, in the month of March 2005, numerous transfers were made to nearly a dozen bank accounts created by the accused with false documents. So, over $2 million were siphoned off with these transfers. Ultimately, Citibank caught wind of the illegal activities after receiving a complaint from one account holder. This alerted Citigroup Investigation Services located in Mumbai, which, after getting in touch with the recipient banks, confirmed the fraud. The accused were detained by the police in Pune, leading to the arrest of 14 other suspects that paved way for further investigation. So now we will go to discuss the very legal issues involved in this landmark case relating to cyber fraud, and that was committed in the year 2005. So the accused were primarily charged under Section 43A and Section 66 of the Information Technology Act. As Section 43A of the IT Act mentions the compensation for failure to protect data, as it provided that where a body corporate possessing, dealing, or handling any sensitive personal data or information in a computer resource which it owns, controls, or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected, as while Section 66 of the Information Technology Act, which provides the punishment to be awarded in an event an offense committed under Section 43A. So as it provides any person dishonestly or fraudulently does any act referred to in Section 43 shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. Aside from the provisions of the Information Technology Act 2000, some sections of the Indian Penal Code and in particularly those sections 420, then 465, 467 and 471 of the Indian Penal Code 1860 were also applied as the very provision of the IT Act was not sufficient to cover the offences relating to data protection as committed by the accused. Therefore, in addition to being charged with sections of Information Technology Act 2000, the accused were also charged with forgery, cheating, conspiracy, and breach of trust under Indian Penal Code. So now we'll discuss the very limitations relating to Information Technology Act of 2000. The Information Technology Act was enacted keeping in mind the evolving nature of landscape of digital technology while aiming for providing legal recognition to e-records and digital signatures, promoting growth in IT sector, boosting innovation in information technology, to name a few. However, the rapid developments pointed out the limitations of the scope of the Act. These included limitation on document types, as the Act did not extend its scope to paper-based documents. Various cyber crimes such as online stalking, bullying, phishing, fraud, etc. were not covered, and the narrow scope thus posed a challenge for authorities to properly conduct investigation regarding emerging digital offences. Thus, there was a need felt for introducing a new data protection bill, and that would seek to address these issues. So, the executive and legislature initiated by introducing a new bill, and that was Digital Personal Data Protection Bill, which mandated at an individual's prior consent for data protection done by the companies and provides guidelines of appointing a data protection officer within each organization. The telecom and finance companies are required to keep customers' data confidential, and this data could only be used with the prior knowledge of the customer whenever required. So, now we'll discuss the very judgment delivered in regard to this landmark case, Pune Citibank Mphasis call center fraud. So the court ruled that the case would fall under the ambit of cybercrime, as the act involved unauthorized access of electronic accounts of holders, and therefore should be dealt under the Information Technology Act. The court also charged the accused under Section 43A and Section 66 of the Information Technology Act 2000, and also under Sections 420, 465 467 and 471 of the Indian Penal Code of 1860, as these were involved the very provisions relating to forgery, cheating, conspiracy, and breach of trust, as the employees involved in the work at the call center and must have memorized the very numbers along with transferring the money using the SWIFT account of the bank. So finally, we would like to conclude our valuable discussion on this very landmark case relating to cybercrime. So the Pune Citibank Mphasis call center case serves as a reminder of the vulnerabilities of the digital infrastructure and the need to constantly keep the law at par with the rapid digital developments to combat cyber crimes. While it came to be known as one of the strictest laws in terms of regulating digital technology, its limitation gave rise to the need for the introduction of then the bill relating to digital personal data protection bill, which ultimately was enacted as Digital Personal Data Protection Act of 2023. To address the very gaps in existing legislation and enhancing proactive measures for data protections, as India is aiming to fortify its cyber security space and develop trust in its digital ecosystem. And finally, the Digital Personal Data Protection Act 2023 was enacted, and consequently the very rules relating to digital personal data protection rules were enacted in this year in 2025. So hereby we complete our discussion on this important case relating to cybercrime, that is Pune City Bank Emphasis call center fraud case.